All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated.
Ladies and gentlemen, buckle up, because this one's messy. We've got a father begging for financial support, a mother who's completely vanished, and a teenager stuck in the middle of it all. Mr. Thorne came into court hoping for fairness. But will the law actually back him up? Or is he about to run headfirst into a legal brick wall? Let's find out.
Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Hold up, let's pause here. You can already see Mr. Thorne isn't in good spirits. And honestly, who would be? He's raising his son on his own while drowning in medical and legal bills. But here's the twist. He already agreed to no child support during mediation. And in family law, unless he proves a major change in circumstances, that deal stands. So here's the question. Should a parent still be held financially accountable, even if they moved away? Let us know in the comments.
Been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
if I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him
Okay.
in that aspect. And, the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay. Here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive.
Whoa, stop right there. Did you catch that? This isn't just unpaid child support anymore. This is turning into a criminal mess. AJ is getting into serious trouble. And guess who's stuck paying the price? His dad. To make it worse, insurance companies don't cover criminal acts. Which means not only is Mr. Thorne drowning in bills, but he risks losing coverage altogether. So tell me, would you let AJ handle his own mistakes, or keep fighting for help?
To be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just free of any obligation? I mean,
well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand.
And here's where things really hit a wall. Mr. Thorne came looking for relief, but Texas law isn't giving him much room. As far as the court's concerned, nothing has legally changed enough to justify adjusting child support. Mediation agreements are binding. Unless there's proof of a huge shift in income, living arrangements, or the child's needs, the judge can't step in. But let's be real. Shouldn't a parent still contribute when their child is in crisis? Sound off below.
There's nothing I can do? Absolutely?
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you.
Okay,
Your
is there
Honor.
anything further?
No, ma'am. Not at this time.
Okay.
That's about it.
Okay, well, if there's nothing further, you're dismissed.
Ouch, that's the sound of reality coming down hard. Mr. Thorne hoped for a break, but the law is crystal clear. An agreement is an agreement. Morally, Mom may not be off the hook, but legally she owes nothing. This is one of those tough cases where fairness and legality don't line up. What do you think? Should the law bend a little in situations like this?
I wanted to go over what you all witnessed in the Thornton case. Dad was appearing in court for the first time. He and Mom settled at mediation for no child support. Well, now he wants Mom to pay child support. Well, under Texas law, in order to modify child support, there has to be a material and substantial change. For example, there has to be a change in the child's mental needs, educational needs, a relocation of the parent, or an increase of income. None of those things took place in this particular case. Everything pretty much remained the same. Therefore, he was unable to get any child support from Mom.
And that's it. Case closed. The ruling holds firm. No material change, no child support. A brutal reminder that once you sign on the dotted line, getting a do-over isn't easy. So, what do you think? Was justice served today, or did the system fail Mr. Thorne? Drop your thoughts in the comments. Hit that like button if this case opened your eyes, and subscribe for more jaw-dropping courtroom drama. See you in the next one.